that the free movement between the UK and the EU has ended. So there's no more right for European citizens to move to the UK and begin a job, or to look for a job, or to just sort of have access to the labour market in the way that they could do when free movement existed. That's finished. That is a major part of the Brexit process, was to end that. And so what you have, though, is you have a group of European citizens, and I talk about, when I talk about European citizens, I'm talking about EU. There's the 27 member states of the EU, the EEA countries, which means Norway, Iceland, and Liechtenstein, and also Swiss citizens. They're all covered in this bracket of European citizens. They, broadly speaking, have exactly the same rights in the UK. And there's also family members who may not be Europeans themselves, but would be sponsored by a European citizen. They also will fall within this bracket when it comes to looking at their sort of immigration position. So you have Europeans who were living here by the end of what's called the transition period, which was the 31st of December 2020. And for those who are living here, they can apply to the EU settlement scheme. That's the scheme that had the deadline of the 30th of June, but we'll come back to that deadline in a little bit. And they are the people who will be granted settled or pre-settled status if you're looking at sort of their immigration position. And then you have Europeans who were not resident here by the end of the transition period and who do not qualify as family members under the scheme. So Europeans who basically don't have any connection to the UK beforehand. And they are subject to the UK's domestic immigration system. Sometimes it's called the points-based immigration system, which is because there's elements of it that rely on people scoring points, but also visiting the UK is also part of the domestic immigration system, which has got nothing to do with scoring points because you're just coming as a visitor. But all of these domestic rules apply to Europeans who do not have any prior connection to the UK. So I'll cover that briefly, but we're more concerned in this session with those who have applied to or need to apply to the settlement scheme. So just to, again, this is a sort of a real overview of what the scheme is and what it's there to do. But the scheme is designed to implement the UK-EU withdrawal agreement, which protects the rights of Europeans who were living in the UK before the end of free movement, and likewise for Brits who are living in the European member states. They have reciprocal rights under the withdrawal agreement. And the settlement scheme is there to implement the obligations that the UK signed up to under the withdrawal agreement. And so the settlement scheme is under UK law in that it exists in the UK's immigration rules, but it's actually giving sort of effect to international rights. And therefore, so it's a very unusual scheme within the immigration rules because it's actually about obligations that the UK has signed an international agreement about. So you can't really describe it as a domestic immigration system because it's not even though it does exist in the UK's immigration rules. When someone applies to the scheme, the idea is that they're applying for one of two statuses. One, something is called settled status, and that is like a permanent residency if the person has lived here for 5 years when they make their application. Or someone gets pre-settled status, which is if they haven't lived here for 5 years, they get sort of a temporary status, which allows them to build up to 5 years of UK residence. And at that point, they make a second application to get settled status to confirm their right to live in the UK permanently. So those are the two statuses available under the scheme. There are other outcomes. Someone could be refused status, for example. Sometimes people don't make applications in the right way and they get rejected as being invalid. But when you look at the statistics of the scheme, the vast majority of outcomes are for settled or pre-settled status. There are sort of two relevant deadlines here. The 31st of December is the important one for people to be resident. If you came to the UK on the 1st of January 2021, you could not apply under the scheme because you weren't resident here before the cutoff date. And then there's the application deadline, which is the one that's just passed, and that was the 30th of June. And that's important because people who miss that deadline have a slightly different situation, and they have to, they'll at some point, we think, will become aware of the fact they missed the deadline, and then they'll need to take action. So it is a crucial date, and I'll explain what happens to people who miss the deadline in a little bit. When someone applies to the scheme, it is actually relatively straightforward for them to make an application. They're just required to show that they are a European national, proving their identity and nationality, show the Home Office how long they were living in the UK, and that they were living in the UK by the cut-off date, or at the end of December. Anyone who's an adult has to make a criminality declaration, so any convictions have to be declared. And then now, sorry, I've moved for 4 and 5 of the wrong way around. I just noticed that. But if someone's a family member, then they're being sponsored, and then they have to show that they have a relationship with the European. So that's an additional stage if you're applying as a family member. And I've put in a number 5 point. I seem to put it in twice there, which is if someone's applying now, they will have to explain why that they missed the deadline, because that's part of the application process from the 1st of July. The system is mainly online. The people were expected to apply online. They were expected to submit their supporting evidence via uploads online, and they receive all communication online. And in fact, when they get their status after being granted, that is also online. So the whole system was very streamlined and online in that sense, which works for lots of people. Some people it probably doesn't work as well for, and that's been one of the criticisms of the scheme, is that it does digitally exclude some people, and I think that that's something which still will need to be looked at as we move forwards, because people, as I say, people who have status still have to access it using online methods, and that's great if you can, but if you're not IT literate, or if you don't have access to the internet, it's problematic. There is a paper application form route, but that was generally reserved for people who didn't have an identity document that could be checked via the online process. So people were expected to apply online if they could, but some people did use a paper application form, which again is something I'll come back to, because it's quite an important issue for those who are still waiting for a decision. It's important to be aware that when people are proving to the Home Office that they are considered like resident in the UK, so that they move to the UK by this cut-off date on the 31st of December, that they'll be expected to maintain something called continuous qualifying residence, which basically it means that they spend enough time in the UK to be considered a resident here. And this applies to them whilst they're building up their 5 years of residence that they need to get permanent status. And it's important that for someone who's in that 5 years of qualifying status, that they don't break their continuous residence, because if they do break their residence, then they will fall out of scope of the scheme, and they won't be able to obtain settled status in the future. The idea is essentially that someone who's resident in the UK lives here for at least 6 months in any 12-month period. So that essentially they spend the majority of their time in the UK. This only applies for 5 years. This is a key thing to understand. It only applies to them for 5 years. Once you've been resident for 5 years, then you can get settled status. And once you get settled status, you can move out the UK for up to 5 years without losing your status. So you have a lot more freedom once you get to settled status. But whilst you're in your 5 qualifying years, which is those people who will be having pre-settled status, they have to maintain their residency in this 6-month rule. And if they don't do that, then as I say, they will be considered to break their residence, and they won't qualify for settled status in the future. Now, there is one exception in this continuous residence rule, which says that if someone has an extended period away from the UK for up to 12 months for an important reason, that they wouldn't be considered to break their continuous residence. So the ones that are listed in the bullet points are examples that are given in the rules, but there could be other things that are not necessarily listed there. Now, that was the sort of standard rule before COVID came along. And then, of course, the world has been turned upside down um, since in the UK since March 2020. And what that means is that the Home Office sort of realised that you couldn't necessarily apply the same strict rules that they existed in under the scheme to the situation with COVID, because it's not a standard situation. It's obviously completely unprecedented. And so what they have is a special guidance document to look at situations where people have been away from the UK because of COVID. I won't go into it in great detail right now, but the important thing to understand is that it has an important concession in it, which says that someone may have actually been away for more than 12 months. And even if that's the case, they're not considered to have broken their continuous residence if they can show it was related to COVID. So that's a very important concession for a lot of people. I personally get a lot of questions about people when they've moved away. They've not moved away for good, they just moved away temporarily, but they want to come back and they want to know how COVID affects that situation. So that's the kind of residency rule, which is key to getting status under the scheme. It's important just to be aware that you may come across family members of European sponsors. In many cases, these family members will be non-Europeans themselves. And it's important to understand that they're part of the settlement scheme because you have different rights. If you're a family member of a European citizen, you have rights under the scheme, which are probably they're more beneficial to you than if you were a non-European who was under other parts of the immigration system. So that's why it's important to understand that lots of non-European family members are connected to the scheme because of their relationship to a European. Relationships that are covered are spouses, civil partners. Durable partners means unmarried partner. And then we have children and grandchildren are covered, and dependent parents and dependent grandparents. So all of those relationships are covered by the scheme. And so a person could apply to get status if they are non-European and they are connected to a European via that relationship. Nowadays, you can also include European family members in that, because if you think about a situation where you have a European couple, like they're married. One of them was resident here by the 31st of December, so they apply under the scheme and get pre-settled or settled status. But let's say that their European spouse wasn't here before the end of December. So normally that European spouse will be excluded from the settlement scheme because they weren't resident by the cutoff date. But because they are in a relationship with a European who does have status under the scheme, they can apply to come and join them in the UK as a family member, so that they still have the right to come under the scheme, even though they weren't here by the cutoff date. And that's the crucial thing to note about family members, is they might still be applying to come to the UK, and they may still be for many years to come. There is a distinction between family members who lived in the UK before the end of December, the end of the transition period, and those who want to come after from January 2021 onwards. There's no difference in the types of relationships that are being sponsored. There's still those lists, the spouse, the civil partner, etc. It's just that if you were a family member already living here by the end of December, then you were supposed to apply by the 30th of June. Whereas if you are a family member who wasn't living here by the end of the December last year, you can apply to come whenever you want. You're not subject to that 30th of June deadline. You can join whenever you want to come and move to the UK, as long as you make the right application. And those family members who weren't living here before the end of the transition period, they are supposed to apply from outside the UK. In the majority of cases, there are some limited exceptions to that, but generally they have to apply outside to get effectively permission to come in under the scheme. So you might see, if you're someone who employs people in the UK, you might see someone presenting what's called an EUSS family permit to you, which is essentially it's a 6-month permit, which allows the person to enter the UK and then apply to the settlement scheme once they're here. But what a person with a valid EUSS family permit has the right to work even whilst they're making their application here. So it gives you those rights, having that family permit. I've said that the kind of status that is being granted is a digital status, like an online status, and that is very important to understand, because this is really the first time that the UK has only issued digital immigration status to those who are subject to immigration control, and so it's a lot of people have been granted status, up to like over 5 million people. And for the first time, they cannot prove their immigration status by using like a physical identity card. They have to use their digital status. And this is very new. It's new to people holding the status, and it's new to those sort of public and private bodies who need to implement the status. So it's something that I think there is a lot of learning around. There is a lot of Home Office guidance, a lot of information, but it's not always apparent to people how it works. And so it's definitely a key aspect of the success of the scheme will be making sure people can use their status. Now, in essence, what someone who holds status would do is they'll go onto a gov.uk website called View and Prove Your Status. They will then they'll be asked for the reference number of the ID document they applied with, which will usually be their passport, might be their national identity card. So put in the reference number, date of birth. A security code is then sent to them, usually to a mobile phone number, but it could be an email, and that allows them to log in to their account, if you like. So it's a kind of online banking, DVLA, driving license type access that you would sort of be used to in some other walks of life. And what comes up when someone logs into their status is their picture comes up, confirmation that they either hold pre-settled or settled status, and then a number of functions within the sort of digital account, which involves they can change the details, they can apply to update details, and they can also generate these things called share codes. And they're very important because the idea of these share codes is that this is what a person would give to an employer, for example, to demonstrate to that employer that the person has the right to work in the UK, because anyone who's an employer out there will know that they have obligations to make sure that they check the immigration status of those who they want to employ, and failure to carry out a correct check can result in Home Office action against the employer for breaking the law, essentially. So these share codes are given to an employer, and the employer then runs the share code through a Home Office website, a different website, and it comes back with confirmation that the person has the right to work because they have pre-settled or settled status. And so that's the idea of this digital status. So for anyone who's sort of used to seeing a physical, like, biometric residence card which says work permitted on it for a non-European employee, that wouldn't happen with someone who has status under the settlement scheme if they're a European. For family members who are not Europeans, they actually still were issued cards, but the majority of people obviously under the scheme are European, and so they don't have those cards. So that's the idea of the digital status. And as I say, it's something that people are getting used to, and it is a new concept, and I think there's an element of making sure or checking to see how successful it is as a way of people being able to evidence that they have the right immigration status to live in the UK and exercise their rights here. Just to cover, like I said at the beginning, that being granted status, settled status, is unlimited. It's permanent residency. So once you have it, you have the right to live here permanently. You would only lose it if you left for more than 5 years in one go, or if you commit a criminal offence, then effectively the Home Office may try to remove you from the UK. So those are really the only two reasons you would lose the status. And someone who has settled status can then apply to become a British citizen if they want to. They don't have to. It is not a requirement for anyone to apply to become British, but it is a gateway to becoming British, and many people who have settled status have applied to become British. Pre-settled status is probably the one that sort of concerns lawyers more, because it's limited. It doesn't mean you have limited sort of rights in the sense that when you have pre-settled status, you still have the right to work, you still have the right to rent accommodation, you have the right to access the NHS. So your rights aren't limited in that context. But what is limited by it is the amount of time that you hold those rights for, because all pre-settled status is granted for 5 years. So at some point within the 5-year cycle of someone's pre-settled status, they need to apply to either get settled status, or if for some reason they can't get settled status because they don't meet the qualifying conditions, they'd have to look for another immigration category to get some status, because they can't, once their pre-settled status runs out, they lose all of their rights if they haven't made an extension application. So that's why it's limited in that sense. And so people with pre-settled status are in a more precarious situation. They need to know that they have to make a second application, and they need to remember when to do it. And if they forget to do it on time, then they have to make a late application, which is problematic. So that's and there's been well over 2 million grants of pre-settled status. So lots of people in this boat where they have to extend. I will just quickly highlight, because I raised it at the beginning, Europeans who don't have any connection to the settlement scheme, they fall under the what we call the new immigration system, and essentially, I mean, really the key thing to note about this is that for Europeans visiting the UK, they do not have to apply for visa in advance. They can enter through the automatic gates, and they are allowed to stay for 6 months. So it's fairly straightforward for visiting the UK. Now, what visiting does not give anyone the right to do is to take employment whilst they are here. You cannot come into the UK as a visitor and get a job. There's the difference between the free movement situation that existed beforehand. And so this is something that probably is taking time to filter down to some Europeans who have wanted to visit the UK. There has been stories, media stories, people may have seen these, where essentially Europeans have tried to enter the UK. They've been asked at the border what the purpose is, because they don't have any visa, because they don't need one to travel here if they're coming as a visitor. And then the person said, well, I'm going to be getting a job whilst I'm here. And at that point, they're going to get refused entry because they don't have the right to come and get a job here as a visitor. They would need a specific visa that is issued in advance if they want to work in the UK. So that's why where issues have been arising, and it's something that will probably continue for some time whilst people adjust to the situation where free movement no longer exists. So if someone does want to work in the UK, so we're still talking about people who don't have any connection to the settlement scheme, they do have to get a visa in advance. Now, the most common working visa is what's called a skilled worker visa. And that is essentially where the employer has a license from the Home Office, and that allows them to sponsor overseas applicants to come and work for them in the UK in the specific role that they are give the person the job for. And they have to issue what's called a certificate of sponsorship to the person applying, which they use to make a visa application outside the UK. So there's the requirement is for people to be sponsored. So there's no ability to come and do whatever work you want. And it is called a skilled worker visa because the Home Office does not allow everyone to be sponsored. Again, if you want to take an example that's in the press at the moment of where this is something that Brexit is causing an issue with, if you look at HGV drivers, there is a lot of problems with a shortage of HGV HGV drivers at the moment, because so many of them are Europeans and they don't have the right to come and work anymore, or they've left because of COVID potentially, and that there is no ability to bring in a sort of in many examples, there's no ability to sponsor someone to come from outside of the UK to come here and be an HGV driver. It's not considered a skilled occupation, and therefore there is now a shortage. And there's a sort of discussion between organisations who represent haulages companies and the Home Office, the government, about whether or not there should be a specific visa route. And the government's position is no, we do not want to open up a visa route in this category. We want you to solve the labour issue from the domestic labour force. So it's a kind of a political battle, if you like, about the implications of Brexit. So that's where you can see the sponsorship system will have a massive effect in certain areas, a lot more than others, I would think. Moving back to the settlement scheme, what we have been, a lot of the work that we have done over the last couple of years has been trying to sort of understand those who would struggle with the scheme for some reason. Now, that might be struggling with the application, it might be struggling with the status once it's granted, it might be just not being aware of that anything has really changed because of Brexit, and all these things have their quite serious implications for people. So trying to understand sort of vulnerable persons who are affected by Brexit has been a key aspect of this work. And it can apply, I mean, it's a very broad definition, I would say, when you talk about vulnerable applicants. You cannot, there are some very sort of obvious aspects of sort of vulnerability where you're talking about things like children in care as of listed victims of trafficking, domestic violence, and so on. But there's also just things like not having English language skills, living in the UK a long time and not thinking that this affects you, or coming very late in the day and not understanding what you need to do. All of these things kind of create a vulnerability, because as soon as someone fails to apply to the scheme, that they become vulnerable or have become vulnerable. So it's very broad. These are just some of the sort of expanding on that aspect. And I think when you look at a scheme that is effectively digital only, that does create its own exclusion. And really the problem there is that if you have to engage with the Home Office to try and explain that you're not digitally very, very good, then you have to do this all in English, or you have to get someone to do it for you, because all the services offered by the Home Office are effectively English only. And so if you can't engage in just in that simple sort of sense of being able to explain your situation to someone, then you're going to have more of a problem. And then there are some of these cases that do create complexities, because as much as there are many straightforward applications of the scheme, there has been many, there are also some that are very complicated. There's some that have very complicated rules for someone to be granted status, and so having a lawyer is essential in many cases. So that's another sort of area where the scheme can be quite complex for people. When we've looked at the older EU population in the UK, we've also sort of seen that this is definitely an area where there has been some concern. The only information about how, like, or sort of breakdown of who's applied to the scheme is statistics that are provided by the Home Office, and they do two statistical releases. One is every month, and then they do a more detailed look every quarter. And in the quarterly report, they will list how many applicants are from the over 65 group. And what you see from that is the last quarter had statistics up to March 2021, and that showed you that 2% of the applications to the scheme were made by those who are over 65. Now, it's not known how many Europeans living in the UK are over 65, but there is probably a feeling amongst a lot of organisations who work with European citizens and embassies who represent European citizens in the UK, that figure is quite low. And so it seems that perhaps this was a group who didn't make applications to the scheme either because they didn't know about it, or because they struggled with the process, or potentially because they didn't need to, because they might have another type of immigration status. They might have become British citizens, and so they wouldn't need to. But no one really knows the answer to that question of why the figure is 2%, and no one knows what the actual percentage figure should be. So it's a bit of an unknown. But I think it's fair to say that older citizens are definitely a vulnerable group who may not have applied. And then within that, you would potentially have older citizens. Now, obviously, capacity is not limited to older citizens, but it may be more prevalent in older age groups. You have issues of whether someone has capacity to make an application, or to even instruct someone to give them the permission to make an application on their behalf. And it's a very problematic area where you are dealing with people who don't have capacity. The Home Office created some guidance about capacity that you can read. It's relatively short, and I don't think it would cover every scenario that you could come across. And so there are definitely still times where, whenever I've had a discussion about capacity, about what someone should do, particularly if they're in a situation where the guidance doesn't make it clear. So the guidance makes it clear that if there's something issued from like a power of attorney, then that person clearly can make an application for them if it's the right type of power of attorney. But if you don't have that, then do you make an application? Do you know whether to or not? And sometimes you can't get the answer from the guidance, which means that you, as an individual who might want to assist someone make an application where they don't have capacity, you're put in a position where you don't know what your liability will be, or whether you have the authority to do it. And so it's a difficult one. The other issue that has affected lots of older citizens is not having ID documents. Either they're expired, or they haven't been able to make it to an embassy appointment to renew the document, particularly because of COVID and all the concerns about traveling, particularly if you're an older person or you're shielding for some reason. So ID documents became quite a big problem with the scheme, because the online system only accepted valid identity documents. It didn't accept anything that was expired up until very recently, like about 3 or 4 days before the deadline applied. The Home Office changed the computer system to allow those with expired ID documents to make applications using the online system, which is very, very late in the day, considering the scheme had been running for over 2.5 years by that point. So people without ID documents, or people without valid ID documents, in many cases had to apply on a written paper form, which involved getting the paper form from the Home Office sent to them and someone filling it out for them on their behalf. And so lots of complexities for people who didn't have an ID document. So moving to the settlement scheme deadline, because obviously, as we mentioned, this has passed now, it has gone, and therefore anyone applying to the scheme now who was supposed to apply by that deadline and who didn't will have to explain their situation to them. But before I move to that group of people, which they're effectively called late applicants, you have another group of people who did make applications in time, so made it by the 30th of June, but who haven't had a decision yet, because there was a surge of applications in June. Obviously, because there was a lot more media, a lot more social media coverage of the scheme, and a lot of people realized belatedly that they needed to make an application. So there were hundreds of thousands of applications in June. And what that's done is built up an enormous backlog at the Home Office, which exceeds, or it certainly did on the last official figures, exceeded 500,000 cases. And so there are many people who do not at this point in time have a decision on an application, even though they would have made it by the deadline as was required of them. So for people in this situation, the idea is that they are not disadvantaged by the fact that they haven't got a decision at the end of this grace period. They are supposed to have their pre 30th, or sorry, pre 1st of July situation protected and sort of frozen in time whilst their application is being processed. And that effectively means they're allowed to work, they're allowed to rent accommodation, they're allowed to make benefits claims if they are eligible for benefits, access the NHS for free, travel in and out of the UK. So there's not supposed to be any restrictions applied to them just on the fact that they don't have a decision yet. People who've applied are supposed to be issued with something called a certificate of application, which tells them that they've applied in time and that they can use to evidence their rights whilst they're waiting for their decision. Most people who apply online will be able to get a certificate of application fairly quickly. People who applied using a paper application form do not get an immediate certificate of application because the Home Office has to check some of the information in the paper form before they can issue the certificate of application. And the Home Office received a lot of paper applications at the end of the grace period, and so there are lots of people who probably don't have a certificate of application yet. The idea was that before or once they make a paper application, the Home Office will send them something. I mean, for the sake of giving it a name, I've called it an acknowledgement of application. That's not an official name because it doesn't really have an official name, but it's the idea is that it's communication from the Home Office which says to someone, you did apply in time. We haven't given you your certificate of application yet because we've got to check some things, but you did still apply in time. And so here you are, we acknowledge your application. And this you can use this until you get your certificate of application. So that's the idea behind it, is to give some people something now. And if you looked at the guidance that's provided to employers about checking rights for European citizens, then that will be they'll be included in the guidance, sort of reference to basically saying if someone can show you they applied in time by giving you confirmation from the Home Office, this will is enough for you to offer them a job, to give you protection from being fined as an employer, basically. So those are the two sort of things that someone should have if they've applied in time. Now, there is a problem within this. Unfortunately, like everything, it's never as completely as straightforward as we would hope, which is that not everyone has received their acknowledgement of application yet. So not even they haven't received the certificate of application, which we know can be delayed. They haven't even been given their acknowledgement of application yet. This is what we're hearing from some support organizations, which means that people who don't have that can't really show that they applied in time, which is problematic if someone wants to see evidence that they applied in time. They don't have it yet. So this is a problem that we're aware of. I'm not entirely sure what solution there is to this problem. It's the solution would lie with the Home Office, but I'm not sure if they have any solution to this issue, because they can't issue the acknowledgement of the application until they've logged the paper form on their system. And so, that takes time when you've got a lot of paper application forms being received. So it can be the case that someone doesn't even have that even first acknowledgement, which is a problem. But ultimately, as I say, if you're looking at someone who did apply before 30th of June or by the 30th of June, that as long as they can show that they applied, that is their position is maintained. Their right to employment, their right to, as I say, to rent, to NHS is maintained whilst they're processing. The situation is different for those who missed the deadline, full stop, because what happened to them, according to the Home Office on the 1st of July, was they became people who didn't have lawful immigration status, and they're people who need lawful immigration status to be able to exercise any rights in the UK. So that's a very dramatic change in someone's legal position because they missed the deadline to apply. It doesn't mean that they can't apply to the scheme. They can. There's a policy to allow people to apply late if they can show that there was a good reason for missing the deadline. But the point is that they don't have any rights whilst they are applying to the scheme, whilst the Home Office is looking at it, until the Home Office issues a decision, and assuming that decision is positive, the person just doesn't have any rights. And so people are going to have issues here because we don't know how many people missed the deadline to apply, because we don't know how many people should have applied in the first place. But if you assume that a good amount of people have missed the deadline, maybe in the thousands, tens of thousands, hundreds of thousands possibly, then for the current time they don't have any immigration status, and they cannot prove that they have the right to do anything. And so they are in a very, very vulnerable situation. And the first thing that someone would need to do once they realize that they needed to apply is to make an application, because the policy on accepting late applications from the Home Office also takes into account whether they've made an application within a reasonable time. It's not just that they had a good reason for missing the deadline, it's whether or not they've made the application within a reasonable time. So if you imagine a situation where someone has a good reason for missing the deadline right now, let's say they were in hospital over the deadline and they've just been discharged from hospital now, you would accept that as a good reason for missing the deadline. But if they then didn't make an application for the next 12 months for some reason, then they might struggle with the aspect of the policy which says, well, it has to be an application within a reasonable time. So that's where that might bite in someone's situation. When someone does apply now, they are asked to show why they missed the deadline, or to explain why they missed the deadline, and wherever possible they're asked to produce evidence to show the reason and to back up what they're saying. What will happen then is the Home Office will consider what the reason was, and if there's any evidence, they'll look at the evidence, and they will essentially issue a decision on, well, they will make a decision at that point about whether or not they accept the application as a late application. If they accept it, then what they'll do is they'll then move on to consider the application under the standard criteria, which is the person showing how long they've been resident in the UK and making any criminality declarations and so on. And so the application is effectively processed as normal after that point. If the Home Office doesn't like the reason given and they decide that it doesn't constitute a good reason, they will issue a refusal decision, and they'll say, you did not apply in time and you did not give us a good reason for not applying in time, therefore we don't think you qualify for status. And if someone gets that decision, really they will have to appeal against that decision if they want to challenge it, because if they just try to put in another application with the same reason for missing the deadline, then the Home Office presumably will just make the same decision all over again. And say, no, we've already told you that we don't accept your reason for applying late. So that's why a person will probably have to appeal against that decision to argue that actually their reason should be defined as good enough. And that will be up to the judge who looks at the decision. So that's kind of broadly how the process works. Some of the examples that are given in the Home Office guidance on late applications are listed in this slide here. Now, it's very important to understand these are not exhaustive examples. So there are many things that could come up that are not on this list, which would still potentially constitute a good reason. It's just that I think the way to sort of think about it is, if your reason is on the Home Office list in their guidance, then you can be fairly sure you're going to be okay. If your reason is not on the list, It doesn't mean that you won't be okay, but obviously you will have to make sure that the Home Office understands that you do have a good reason. So that's probably the difference between the types of examples given in the guidance and those which might exist outside of the guidance. I think one that's quite interesting is under the one that says other compelling or compassionate grounds. The Home Office includes in that situations where people didn't know that they needed to apply. So if you just simply didn't have any understanding of the scheme, because all of the social media and the communications campaign missed you out for some reason. If you're in that situation, then the Home Office says, for the time being, at least, we will accept that as a valid reason. Well, that seems to be what they're saying. And also for those who for some reason thought they didn't need to apply, let's say someone who's lived in the UK a long time and thought that meant that they were exempt, that's also included in these reasons, which is important. The Home Office has sort of said about their late applications guidance that they will keep it under review and they might make changes later on. And probably what this will look like is them saying, as we move away from the deadline of the 30th of June, there'll be less reasons that we consider valid for applying late. And so the guidance might become more restrictive in time. It's something that we'll obviously want to monitor as the sort of support organisations who work with EU citizens. So that's covering late applications. I'll just want to come to something, employer checks, because it's important to understand that, because the position, as I've explained it, is essentially if you applied in time, then you maintain your rights until you get it, whilst you're waiting for your decision, which means like the right to work, etc. And if you applied late, you've lost the right to work, and that is completely a correct statement of the law, and it's a correct statement of the way that the Home Office has created the system. Now, what the Home Office has done is they've created a sort of a type of mitigation, a way of possibly reducing the impact of people missing the deadline to apply, by saying that for someone who misses the deadline, so that person who then loses their right to work, the Home Office in their guidance to employers has said, well, if you're the employer and this is your existing employee and they miss the deadline to apply, even basically what they're saying is, even though they don't have the right to work, we will allow you to keep them in employment if they make an application within 28 days of you realizing that they missed the application deadline. And if they do that, and they show this to you as the employer, this is the policy. It's a little bit heavy in the text, but they say that you can actually keep the employee on. You don't have to terminate their employment because they missed the deadline. And if as long as you make the check that they did apply, then you have an excuse. If the Home Office then try to challenge you and say, oh, you seem to be employing someone without lawful immigration status, then you have a defense against that by saying, well, actually, this person was in my employment before 30th of June. They're an existing employee. They're European, or potentially a family member of a European citizen, although the policy isn't quite clear on that, the family member situation. But if it's a European, then you say, well, they were in my employment. They have now applied, even though they missed the deadline. I've got proof of their application. I was allowed to keep them on because I also got a check from the employer checking service, the positive verification notice, and therefore you have a defense against that person, about maintaining that person's employment, even though they missed the deadline. So this is a sort of small concession within the right to work guidance for employers. It doesn't apply if someone is a sort of comes to you as a new employee. If someone approaches you and says, I want to become an employee, and at that point you say, well, have you applied to the settlement scheme? And they said, oh no, I've missed the deadline. If that's the situation of the person, then they do not have the right. You cannot employ them, or you'll be committing an offence if you employed them effectively. So this kind of policy of reducing the impact on late applicants only applies if the person's in your existing employment. But yeah, all this can be found in the employer's right to work guidance. Although I have to say it is quite complicated. It feels quite dense to try to work through the policy. So just coming back to those who do have status, and obviously again as an employer, for new employees, if they will be required, if they have the status, to prove this to you by giving you the share code. I've already talked about the share code, but just so it's important to understand what you need to do as an employer to check that status and make sure that you keep a record of it, so the Home Office comes knocking at your door, you can show that you did the right thing. But yeah, it's difficult because this is a new system. So like any new system, it's going to have teething problems. It's just not quite clear at this point how large those teething problems will be, but it's very important that people do understand what digital immigration status is and how to access it, and how to make sure that people are not discriminated against because they have digital status versus a physical identity card, because they have the same rights as that person with the physical identity card. They have the same rights as a British passport holder to work. So that's important. I've covered pre-settled status and the fact that you do need to make a second application. So it's just something that we highlight as a kind of vulnerability issue for some people. So just to be clear that those who are granted pre-settled status, it has an expiry after 5 years, and they do need to apply. Otherwise, they become a late applicant again, and it's the same thing that I've already run through. They can still apply late, even if they've missed their pre-settled status to settled status conversion deadline, but they then lose their rights while they're waiting for a decision. So they're back in the difficult situation that someone would be today if they missed the deadline. So just the end of the presentation. Sorry, that is the end of the presentation. There's just some information about useful gov.uk websites, useful commission information, things from the Greater London Authority Hub is very useful. It has lots of information, and there's an EU rights webpage which we run with the delegation, and gives information about the scheme and so on, and